Welcome everyone throughout the continent, all over the world, wherever you are. We welcome you to today's session on Module 4, which is the final installment of our online training for legal practitioners and CSOs on the engagement with the African Court and African Commission on Human and People's Rights, convened by the African Court Coalition with support from the Raoul Wallenberg Institute of Human Rights and Humanitarian Law. As I said, this is our fourth and final module. And the objectives of this module, or the training as a whole, were mainly two. The first one was to enhance the knowledge and capacity of legal practitioners, to enable them to effectively and strategically engage with the African Court and African Commission on Human and People's Rights. And secondly, the other objective is to increase our awareness and understanding of the available implementation mechanisms and effective ways to follow up and to influence implementation of decisions of the African Court and the African Commission. With those objectives, the expected outcome of the virtual training is that there should be enhanced knowledge among legal practitioners and knowledge in respect of engagement with the African Court and the African Commission on Human and People's Rights, so as to enhance access to justice in Africa and implementation of human rights decisions of these two institutions. So those objectives are culminating into this expected outcome. And over the period, Module 1 on the 1st of October focused on the rules of procedure of the African Court and the African Commission. Do you agree with me, those who attended that session, that we were taken through the rules of procedure of these two institutions, but more particularly, the new rules that have been introduced by the two institutions in order to enhance the operations of the court and the commission. And we advise that these new rules are available for download on the respective websites of the two institutions. On Module 2, on the 8th of October, we looked at the strategic engagement with the African Court and the African Commission on Human and People's Rights, as well as lessons from the other regional human rights systems. In other words, we had a presenter, Florencia Regiado, from the Indo-American system of human rights, who shared experiences of their strategic engagement in that region. And we had a number of lessons that we learned, how their own court and commission interact, their jurisprudence, and access issues, all sorts of things that we learned, which are really beneficial to our own understanding of our own system and how we can improve our own system. And Module 3, which took place on Monday this week, looked at inclusion of gender issues while engaging with the African Court and the African Commission on Human and People's Rights. So the two presenters, Eric Bismana and Judy Gitao, spoke eloquently, shared their very incisive ideas on how to understand gender, in the context of engagement with the African Court, engagement with the African Commission, how to encourage lawyers and other players at the national level to identify cases that they should be able to bring before these two institutions. And finally, today, we have a presenter who is going to take us through implementation mechanisms at national and regional level, as well as looking at effective tools to follow up on implementation of decisions of the African Court and the African Commission. If you look at these four modules, they really tie up together. Why do I say so? If you recall the rules of procedure, the new rules or some of the new aspects in these rules were to do with the implementation of decisions of the African Court and decisions of the African Commission. And we're taking through those rules, how to show us the thinking of the court and the commission in terms of how to better implement and monitor implementation of their respective decisions. And today, the module today is exclusively dedicated to the issue of implementation, to give us a better understanding of how these two institutions, their decisions are being implemented at national level. I'll take this opportunity to introduce myself again. My name is Tarisai Mutangi. I am moderating this fourth module. I've been moderating all the modules, and I am so sad that I'm going to moderate the final module. Otherwise, this has been a very interesting and eye-opening process throughout the month of October. However, today we have Dr. Japheth Bigon. He is the one who is going to take us through both sessions of the presentations today, one before lunch and the one after lunch. And Japheth is a legal and policy expert on the normative and institutional architecture of the African regional human rights system. He has more than 15 years professional experience practically engaging with, writing on, and teaching about the African human rights system. Japheth is currently the Africa Regional Advocacy Coordinator at Amnesty International. He leads its advocacy engagement with the African Union and diplomatic representatives accredited with the African Union. He is also an adjunct lecturer at the Center for Human Rights, University of Pretoria, where he teaches on the master's program in human rights and democratization in Africa. He was previously the Director of Investigations at the Kenya Independent Policing Oversight Authority, where he led and supervised investigations into police misconduct. And between 2011 and 2013, Japheth was the Director of Research at the Kenya Truth, Justice, and Reconciliation Commission. In this role, he conceptualized and steered of the Transitional Justice and Reconciliation Commission reports. Dr. Bigon holds a Doctor of Laws degree in International Human Rights Law from the University of Pretoria. So this is our presenter today, colleagues, ladies and gentlemen, and we can't wait for him to take us through his thoughts on this subject, which is of personal interest to me, on implementation of decisions of the African Court and African Commission. And remember, we allow him 30 minutes to present or to share his ideas with us. Thereafter, we'll put some questions and some comments to him to react or just to generally contribute to the discussion on the subject matter of the day. So, Japheth, please unmute your microphone and your video. We would like to see you as we take us through your presentation. Thank you. Japheth, you have the floor, please.
Thank you, Tarisai. I think the IT team will need to activate my video from their end first.
Okay, we can see you now.
Thank you, Tarisai,
Please go ahead.
and the organizers of the virtual training that has taken place in the course of this month. I've followed it, and I think, as Tarisai said, it has offered important insights into the working of the regional bodies and how civil society and litigants can engage with them. And it gives me really great pleasure to be part of this exciting, insightful training process. And I'm glad to be in this process with Tarisai. I can see Robert Eno and other individuals who have actively engaged with the African human rights system for the last decade or so. So I'm happy and also to focus on this topic, which, as Tarisai said, really ties up everything because as I'll be speaking shortly about, implementation really is at the heart of the African human rights system or any other justice system that seeks to protect and promote human rights. My first session will focus on the mechanisms and tools that are available at the regional level, established by these institutions and their practice on how to follow up, on how to monitor implementation, enforcement, and compliance with their decisions. Then the second session, as Tarisai has mentioned, will focus on how states receive these decisions at the domestic level and how they put mechanisms to implement those decisions or not, and what civil society and litigants can do to induce, to encourage, to promote implementation such that the decisions of the regional bodies can have meaning in the lives, in the lived realities of the complainants or the victims. And to start off, I thought we should perhaps begin with 3 quotes. I wonder whether could it be confirmed that you can see my screen?
Yes, Japhet, I can see your screen. Please make sure it's on slideshow. So
okay, now it's on slideshow.
Yes, yes, yes. Please go ahead. We can see it clearly, at least for my
Thank you so much. So I thought to start off this conversation, and it is really a conversation where I'm going to present my thoughts about the practice on implementation and monitoring by the Commission and the Court. But I thought to start off to begin with 3 quotes that from the bodies themselves that appear in their activity, most recent activity reports of these bodies. The first quote is from the African Commission on Human and People's Rights. This is from their 47th activity report, where they say that the level of compliance by state parties with the Commission's decisions, requests for provisional measures, and letters of urgent appeal is relatively low. The second quote is from the African Committee of Experts on the Rights and Welfare of the Child. This discussion today will focus on the Commission and the Court, but I think it is important for us to appreciate that there is another body, a regional body that focuses exclusively on the promotion and protection of children's rights. In their latest report presented to the African Union and adopted in February 2020, this is what they say about implementation. Monitoring state compliance with the decisions and recommendations of the committee is therefore key to the full realization of children's rights. Despite this fact, the committee is facing challenges due to non-implementation of states with its decisions and recommendations. And the final quote is from the activity report of the court for the year 2019. In that report, and in relation to implementation or compliance, they say that compliance with the court's judgment is essential to the success of any justice system and the proper administration of justice. Non-compliance not only destroys the very raison d'etre of a court, but undermines basic confidence in the justice system. I thought these 3 quotes really brings us to the context in which this discussion must take place. And the first is that really implementation is at the heart of the regional human rights system. It is at the heart of what the Commission and the court are doing on a day-to-day basis. Victims, complainants of human rights violations submit cases to this system in a view to vindicate their rights and ultimately to ensure that the right that they have been denied is restored, that whatever they are seeking before the court is provided, and that they are able to benefit from the case that they have lodged before the court. Absent implementation, therefore, the system as a whole is almost rendered meaningless, because in the end, we want to see victims, complainants benefiting from the cases that have been adjudicated. Of course, it's good for jurisprudence and pushing boundaries for these institutions to render the decision that they render. But in the end, it is for victims and complainants to benefit from those decisions. And what makes those decisions from a PDF format or from a paper or from a decision to live the reality of victims? It is the implementation of those decisions that makes the difference. And we have seen that in the system over the years, as it has grown and matured, the question of implementation has become even more prominent, not just in discourses within the academic circles, but also within the policy discourse and activities. And in this light, we have seen these institutions over the last decade or so increasingly paying more and more attention on the question of implementation and establishing mechanisms and tools to ensure that their decision is implemented in practice. And this focus, this attention, almost an obsession on the question of implementation, has come about also because there has been what people have referred to as an implementation crisis or deficit. And this is because of the low compliance, as we have seen from the quotes of these institutions, the low compliance by states on the decisions that the bodies have issued. In 2007, one of the most leading studies on the extent to which states have complied with the decisions of the African Commission, it found really low compliance of decisions of the African Commission. Of course, these findings are today dated, but as we will see later, for instance, the African Court, for instance, says that only Burkina Faso has complied fully with these decisions. The rest of the countries have either partially complied or some have not complied at all, and others have said that quite brazenly, quite openly, that they will not comply. So there is an implementation crisis within the system. But I must mention that this implementation crisis is not really completely unique to the African system. It is a problem that cuts across the regional systems in Americas, in Europe, but also the international system within the United Nations mechanisms and bodies. So it's in this context that the question of implementation has gained prominence, and we've seen an increased focus on this issue. But then you might ask, why should states implement, comply with the decisions? And what is the statutory basis for them to do this? Do they have an obligation to do that? And in this context, we have to go back to the founding treaties of the treaties that established the Commission and the Court. And there's always been a long discussion that continues, and maybe an answer may not finally be reached, because there's also going to be debate about this. But especially states have always argued that because the decisions of the African Commissions are recommendations, then they are not binding on them. And therefore, they are not bound to implement those decisions in practice. But the African Commission, scholars and practitioners within the system have also argued, and I think this is a valid argument, that the state members, state parties to the African Charter have an obligation under Article 1 to implement the decisions of the African Commission. Article 1 provides that the member states shall recognize the rights, duties, and freedoms enshrined in this charter, and shall undertake to adopt legislative or other measures to give effect to them. Here, the argument is that other measures as defined under Article 1 should include complying and implementing with the decisions of the African Commission. Actually, it will be an absurdity for state parties to create the African Commission, give it the power to interpret the African Commission, give it the power to determine communications or complaints and issue decisions, then turn back and say that those decisions are of no value at all. So on the basis of Article 1, it has been argued and agreed that states have an obligation to comply and implement the decisions of the African Commission. And a series of Executive Council or African Union Assembly decisions always encourage and ask state members to comply and implement with the decisions of the African Commission. But when it comes to the court, this argument does not arise because the obligation of states to comply with the decisions of the African Court is clear and unequivocal. Article 30 of the African Court Protocol provides that the state parties shall undertake to comply with the judgment in any case to which they are parties within the time stipulated by the court and to guarantee its execution. So indeed, if you follow historical development of the Commission and the court, it is this argument about the soft law nature of the recommendations of the African Commission that contributed to the establishment of the court as a judicial body that will be issuing binding decisions that states are duty-bound to comply. But also generally, you may know about the principle of pacta sunt servanda under the Geneva Convention on the Law of Treaties, that states parties to any treaty have to comply with the provisions of a treaty in good faith, which would include the decisions, the judgments, the views, the recommendations of a body that is established to interpret that treaty. So I thought as a background to our discussion, just to keep that in perspective, that states are duty bound to implement the decisions of both the court and the commission. Let's now move into the possible models.
Yes, Jafet. So yes, as we move on to the to your further points, just remember to speak a little bit slower so that our interpreters are able to catch up with you and be able to interpret. You know, the virtual connection may have delayed delivery times, you know, on the devices. So just take that into account. Thanks. Otherwise, please go ahead.
Thank you. Thank you. I'll try to slow down a little bit. How can we think about monitoring of implementation? There are several ways of conceptualizing or thinking through how implementation takes place in practice. One way is what we may refer to as enforcement model versus persuasive model. The enforcement model really involves sanctions for non-implementations, naming and shaming, pressure, peer pressure from the regional intergovernmental body or from other states. This essentially is using coercive mechanisms or using coercive force for states to comply or to punish them for non-implementation. Enforcement model is usually applied or used by political actors. As you know, the commission or the court does not have sanction mechanisms, does not have a court or a police to enforce its decisions. So the enforcement model is really a model that is applied by state parties or the intergovernmental organization under which the court or the commission operates. You can distinct this or contrast the enforcement model with the persuasive model of monitoring implementation. This really is about a dialogical approach to the question of implementation, whereby the regional body engages with dialogue with the state party concerned to induce, to promote, to encourage implementation. The persuasive model of implementation, according to scholars, is really based on what they refer to as managerial theory of compliance. This means that states will comply to the extent that they have the capacity to do so. And therefore, the regional body that is concerned, the court, the commission, or the AU political organs have to work with the state here concerned to ensure that they have that capacity and the political will to implement the decision. The second way of thinking through implementation is to think of it in terms of political versus judicial model. And by political here, I mean that it is a political body that is responsible for monitoring implementation of decisions of the treaty body. So it is not the treaty body itself, but the parent organization where you have the political organs that are responsible for monitoring implementation. The political model has been championed and has worked relatively well within the European regional human rights system, where the Council of Ministers has been given express mandate and duty to monitor the implementation of the decisions of the European Court of Human Rights. So within the Council of Ministers, there is a department that focuses on execution and implementation of decisions. And it is this body that prepares reports about the extent to which state parties have complied with the decisions of the European Court of Human Rights, or previously the European Commission on Human Rights. You can contrast the political model with the judicial model. The judicial model is where the treaty body itself, either the Commission or the court, has the express mandate to monitor its implementation and has put in place mechanisms to monitor implementation of its own decision. This approach has been made prominent by the Inter-American Court on Human Rights, or the Inter-American Human Rights System, where the court takes proactive actions to monitor its implementation through a variety of activities, including implementation hearings and preparation of reports on implementation. But both models, political and judicial models, have their own merits and demerits. Depending on the system and the rule of law, the extent to which the rule of law applies within that system, it can be successful or not. And therefore, increasingly, we see the emergence of a hybrid model, a model that combines both the political model and the judicial model. This means that the political organs, like the Council of Ministers, or in the context of the African Union, the Executive Council, has the duty to monitor, but it works hand in hand with the judicial or the quasi-judicial body, which may help them in preparing, for instance, compliance reports. Then these reports are submitted to the political organ, which then makes a final decision on what should be done in cases of non-compliance. As I will be speaking later on this aspect, this is the way that, for instance, the African Court is proposing in terms of monitoring and reporting on its decision. Then finally, you can also think about implementation in two ways, reactive or proactive. Reactive is where the treaty body waits for information from the state party concerned and then acts on that information. Proactive is where the body, either the court or the commission, goes out on its own initiative to look for information, to verify that information, and then prepare its own report. So you can think of monitoring implementation on those three broad arrays. Then let me begin with how the African Commission has dealt with questions of implementation. The African Commission is so far the oldest body on the continent, having started its operations in 1987. For the almost 2 decades of its existence, the question of implementation did not feature so prominently in its work. But at least beginning in 2006, we started seeing it focusing more actively on questions of implementation and compliance and asking states to comply with the decision. And over the period since then, it has used various tools and mechanisms within its mandate to focus and monitor how states comply with these decisions. One, of course, has been the use of thematic and country-specific resolutions. So we see in 2006, the African Commission adopted the resolution on the importance of implementation of decisions. And I think, for instance, I think this was one of the highlights in terms of really bringing questions of implementation to the agenda and center of the African Commission. This resolution asked state parties to comply with the decision after a study that was compiled by the Commission itself found that very little had been done by state parties in terms of implementing decisions of the African Commission. Then after this 2006 resolution, we see now the African Commission also adopting country-specific resolutions that call on specific countries to comply with the decisions. We've seen a resolution in 2006 on Eritrea, in 2006, yes, on Eritrea, asking Eritrea to comply with the decision on Article 19 versus Eritrea that concerned 19 individuals who had been detained in that country. Then there was also another reference to a decision in another resolution that concerned Cameroon. But perhaps the most country-specific resolution that touches to the heart of implementation is the 2013 resolution calling on Kenya to implement the Endores decision. This is the one country-specific resolution where we see the Commission coming out very clearly with a resolution that focuses on implementation of a specific decision by a specific country. Apart from the thematic and country-specific resolutions, it has also deployed the state reporting procedure. So we have seen the African Commission mentioning and asking states during the reporting procedure, have you complied with this specific decision that we issued on such and such a date? And then the state response. And in the concluding observations, we have seen the African Commission asking states to specifically comply with specific decisions. For instance, concluding observations on the state party periodic report of Mauritania in 2012. You'll find there a line that asks Mauritania about compliance with a previous decision of the African Commission. The same applies to the concluding observations on the 8th to 11th periodic report adopted by the African Commission in 2016. Another mechanism that the Commission has used is country visits, either promotional or advocacy missions where it visits a country, and during that period it has used that opportunity to ask the country and the extent to which it has complied with the decision of the African Commission. We saw it, a visit to Kenya in March 2010, just shortly after the Endores decision had been issued. We saw it way back in 2005, a mission to Botswana when the African Commission had issued the case of Modise versus Botswana, using that opportunity to ask the Botswana government whether it had complied or to what extent it had put measures to implement that decision. Another recent model or a recent tool that has emerged but has not been used consistently or even at all has been the possibility of referring cases of non-compliance to the African Court. Some of you might remember before these new rules of procedure that the African Commission adopted in June, there was a provision in the 2010 rules of procedure that empowered the African Commission to refer cases to the court in cases of non-compliance. But the Commission never really used this rule until in the current rules of procedure, the rule has now been effectively repealed or removed. But there was one instance in the Libya case, the Gaddafi case, where the African Commission issued provisional measures. And when the Libyan government did not comply with those provisional measures, it then took the case to the African Court. But it was really in a broader context of taking the entire case to the African Court rather than just on the question of non-compliance. But this gives us an insight into how this referral system would have worked if it would have been put in place and used much more consistently. But these are really ad hoc monitoring rules, tools that at the disposal of the African Commission. Because of the prevalence of non-compliance, the Commission in its 2010 rules of procedure for the first time now put in place a more elaborate mechanism for monitoring the implementation and compliance of its decision. And as we know, that was in Rule 112 that provided for a whole range of procedure that would lead to the African Commission determining whether a state has complied or not. Now, in the current 2020 rules of procedure, we now have Rule 125 of the rules of procedure that provides for the mechanism for monitoring implementation of the decisions. And it has at least 4 quick elements that I would want to mention. One is reporting by the state party. So after the commission has issued a decision, the state party will be given 180 days, 6 months, to send an implementation report on the extent to which it has complied. It may be asked for additional information within 90 days. And if no reminder, if no response is received, the commission may ask, may also send a response. And this, in the new rules of procedure, Rule 125, the observations of the state may also be sent to the complainant to make his or her comments. Then there is the second element, is the reporting by the African Commission itself. So Rule 125 gives the African Commission an opportunity to identify a rapporteur who will be responsible for following up and monitoring implementation. This rapporteur is required to present the activity, a report during the open sessions of the African Commission or ordinary session, explaining the extent to which the decisions that fall under him or her have been complied with. Additionally, the African Commission nowadays have a section in its activity report where it indicates the extent to which certain decisions have been complied with. As I will be mentioning later, in the latest activity report, there is a mention, for instance, that Cameroon has complied with a decision. Then Rule 125 also has, gives the African Commission the power to request national human rights institutions to monitor those decisions and present a report to the African Commission. And then finally, where there is obstinate non-compliance that has persisted for some relatively long period of time, then the African Commission can refer that case of non-compliance to the African Union political organs, and in this case, the Executive Council. And it has done so previously, for instance, in the case of Botswana, which clearly indicated to the Commission that it will not comply in the case of Kenneth Good versus Botswana. And the African Commission referred Botswana to the Executive Council for appropriate action. So this is the formal mechanism that has been established within the African Commission for monitoring implementation. And this process takes place in the bigger context of the Working Group on Communications, which has the express mandate to follow up the status of implementation of all decisions of the African Commission. This then brings us to examples that I've already mentioned. For instance, the African Commission in the case of Cameroon. This is quote comes from the latest 47th activity report, where the Commission says that Cameroon has complied. The only flaw that I see in this kind of reporting, that it does not really unpack what really Cameroon has done. And therefore you are not able to tell, looking at the decision that the African Commission gave and this paragraph, whether the decision has been complied with to the satisfaction of the complainant. And again, I said in the Kenneth Good case versus Botswana, where the African Commission reported Botswana for non-compliance. This remains actually the only case where we have seen a clear case of reporting to the Executive Council on non-compliance. Let's move to the African Court and what has been the practice so far. And I think any discussion on implementation in relation to the African Court must begin with the 2 provisions in its founding treaty. Article 29(2), which provides that the Council of Ministers shall also be notified of the judgment and shall monitor its execution on behalf of the Assembly. So it seems that the African Court Protocol provides a mechanism, a political model of monitoring implementation. But then the question is, how will the Executive Council monitor this implementation without information from the court on the extent to which a specific state party has complied? And therefore, for this reason, we'll see how the system is moving towards a hybrid model of implementation. You must read Article 29.2 with Article 31 of the African Court Protocol, which says that the court shall submit to each regular session of the Assembly a report on its work during the previous year. The report shall specify in particular the cases in which a state has not complied with the court's judgment. So Article 31 is very clear, giving the court a mandate and an obligation to report countries that have not complied with judgments or decisions to the Executive Council. And it is on basis of this information supplied by the African Court that the Executive Council would act in accordance with Article 29.2. So over a period of time since it started issuing decisions, the African Court has provided an annex or a table in its activity report that mentions all the decisions that it has issued and what the respondent states have done. So it's quite an extensive, elaborate data that is being quantified within the context of the activity reports of the African Commission. And it's on this basis that the court can confidently say, as it has always said in its previous activity reports, that it's only Burkina Faso that has complied, while Cote d'Ivoire in a recent case has submitted an implementation report, and Tanzania has partially complied in relation to certain cases, and that some other countries, including Kenya, Rwanda, and other countries have not complied. So in the activity report, you will find this information, which is based on information that the court receives from the respondent states themselves. Earlier on, the court had issued at least a single report that focused on a single case. So this is in the Libya case, where the court actually now issued a report specifically dedicated on non-compliance in the African Commission versus Libya case in 2013. But I think subsequently, we have not seen similar reports that focus on specific cases like this. And I guess this relates to the fact that with more and more cases being finalized and more cases to follow up in terms of monitoring compliance, it has become necessary to resort to the table that then contains the list of all cases. But then we have seen the adoption of the new rules of court that came into force in September. The previous rules of court did not provide for an implementation or monitoring procedure. But now we found in Rule 81 of the new rules of procedure an elaborate procedure for monitoring implementation by the court, so that it can collect the information that is needed to be supplied to the Executive Council. Now, Rule 81 gives the state a period of time within which to submit compliance or implementation report. This report is then forwarded to the complainant for observations. And one crucial aspect in Rule 81 is that the court may also collect and obtain relevant information from credible sources at the national level or even at the regional level. And then if there is a dispute as to the extent to which compliance has been, has happened or implementation has taken place, the court, like the Inter-American Court now, can hold implementation hearings, and in which the outcome of which would form the basis of the information that goes to the Executive Council. And then Rule 81 also says that non-compliance in accordance with the treaty will be submitted to the Executive Council. There is an issue that came up that the court addressed in one of its activity reports, that the Executive Council, and this really points to the deficiencies and shortcomings of a political model of monitoring implementation. In 2018, the Executive Council decided that it will no longer mention countries that have not complied with the judgments of the court in its decisions that concern the court. Quite a retrogressive decision. And despite the fact that the president of the court tried to explain that Article 29 as read with 30 really provides for this mechanism of specifically mentioning countries that have not complied. The Executive Council was adamant that it will not be listing the countries that have not complied with its decisions of the court. But it seems that the Executive Council has been speaking from both sides of the mouth, because at the same time, dating back to 2014, it had asked the African Court to develop a framework for reporting and monitoring of its execution of judgments of the court. And it is in this context that we saw in January 2018, the African Court submitting to the Executive Council the draft framework for reporting and monitoring of execution. This is a framework that had been developed over a period of time involving a consultative process with various actors. And it comes up, as I'll be mentioning shortly, with a hybrid model, and stipulates very clearly, very elaborately, how the court will be handling cases of non-compliance, but also just how it's going to monitor its decision. And it has several elements that I could quickly mention. The first is that it adopts a hybrid approach to monitoring, as I initially said. So it tries to infuse or merge the political model with the judicial model of monitoring. Then an important aspect is that the court will set up a formal monitoring and reporting unit within its registry. This will be responsible for gathering information and data on implementation, and then deciding, providing proposals or advising the court on what next steps needs to be done. The framework also recommends that the AU Legal Council, the Office of the Legal Counsel, and the Secretary General within the AU Commission appoints focal persons that will serve as liaison and officers between the court and the AU, the African Union. And then the unit, the monitoring and reporting unit, will prepare a template for reporting by states. So when a state is asked to report within 180 days, for instance, it will also receive a template that will tell, that will give it that this is the format in which you need to
we seem to have lost Japhet there.
Sorry, I think I'm back now. Can you hear me?
Oh yeah, you're back. Please, thank you. You can continue, please. But we don't seem to see you. But if your network requires you to use less bandwidth, you can you know, but you can't switch off the. You can switch off the probably. Yes, please. Thank you. Please go ahead, Japhet.
So finally, I just wanted us to show you the proposed monitoring and reporting procedure that the court has proposed to use. We are saying proposed because the AU relevant specialized technical committee is yet to review and approve the monitoring framework. Then it will go for formal adoption to the PRC and the Executive Council. But if it remains unchanged, this is how things will unfold. So step one would involve, of course, the delivery and dissemination of decision. And in this regard, the protocol provides that the decisions of the commission will be issued in public and then sent to the state party and other members, other state parties to the court protocol. Then the state reports on implementation of measures using the template that the reporting and monitoring unit has prepared. Then the third step will involve the court assessing compliance on the basis of the report submitted by the state. Then at this stage, even an implementation hearing may take place, you remember, if there is a dispute as to the extent of the implementation. Then the court will submit the report to the Permanent Representative Committee, essentially it's to the Executive Council through the PRC. The PRC will consider the report of the African Court on implementation. Then it will come up with a proposal on what needs to be done. The PRC report and the court report will then be submitted to the Executive Council, who will consider the report and make a decision, which decision will then be submitted finally to the AU Assembly for adoption. This might change because of recent changes in the African Union delegating. Sorry about that. My son is speaking about his aquarium. The assembly, I was saying that the assembly may in future not be the body responsible for final adoption of the compliance or non-compliance report because of recent changes in the AU, given the AU nowadays will be holding one summit per year, and it has delegated the authority of considering reports of many organs of the African Union to the Executive Council. Then finally, if the full compliance has been achieved, then the court will close the case and archive the report. So that will be the process that will be taking place in future in terms of the court monitoring and reporting on compliance of its decision. I might have exceeded 30 minutes, but I guess I've created enough fodder for discussion, questions, and comments. Thank you so much. Tarisai, over to you.
Thank you, Japhet, for your presentation. Really on an issue of interest to many. I mean, it's a logical, like we said last time, it's a logical conclusion of any litigation process. You want to see, if you're a legal practitioner, you want to see the remedy that you have requested from the court, you have been given that remedy, or your client has been given that remedy. It's not good enough to hang it on the wall and say, it's a decision that you got in our favor from the court. What you want to see is full implementation of the orders of the court. And by so doing, we can say that the violation of the treaty consent has been redeemed. It is not sufficient just to have a court decision that says, yes, there's a violation. Of course, in some cases, it's regarded as sufficient reparation just to have a court decision that says, that acknowledges violation of your rights. But where there are specific orders that the court has given or the commission has given as recommended, it is important that the state party concerned genuinely implements or adopts measures specifically to give effect to that decision. Then
it seems we have lost Tarisai.
I think you had lost me there, had you not?
Yes, we had lost you.
Oh, you had lost me. Okay, fine. Maybe I'm talking too much. Let me go straight to the questions so that I'll give you a chance to respond to them. So, yes, I was just making those remarks to say that we need to see a full and genuine implementation of decisions of the court and recommendation of the commission, of the committee as well, so that the lives of our people are changed by the decisions that are given by our institutions. And as I was just saying that, there is a question that came so early in the discussion, which says from Chris, it says, I really like articulations of Article 30 of the African Court Protocol. However, Article 1 of the African Charter and Article 30 of the African Court Protocol sound more academic than touching to the real life of African citizens who need justice. Chris did not explain further to say how, in what sense are they academic and not touching on the real life. But I think, Japheth, you can make some conclusions based on that contribution to say probably how can we make it practical and so that it can change the lives of the people who are looking for justice in Africa. And so that would be your first question, Japheth. And I want to recognize the hand of Dorothy, who put up their hand quite some time now. I would like to give them a chance to make their contribution. Dorothy, would you like to make your contribution now? Dorothy, you can go ahead, please. Dorothy? Okay. We'll give a chance. We'll give Dorothy a chance, another chance probably to connect and make their contribution. Japheth, what would be your reaction to to Chris' observation or question or comment vis-a-vis Article 1 to 30 of the Charter and the Protocol, respectively?
Yeah, I think Chris is alluding to the gap or deficit between what the law says and what happens in practice. So it's clear that states have an obligation to implement decisions of these bodies, but in practice, they do not. That does not detract from the validity of the provisions of these founding treaties in themselves. But it also just points actually to the relevance of this discussion and the relevance to the next discussion about how do we induce states to implement decisions and abide by the obligations which they have freely undertaken under the respective treaties that they have ratified. But also, we also have to understand that we are speaking about international human rights law, but also this law operates side by international relations and politics. And relations and politics also play an important part of implementation and compliance. And that's why even many writers, scholars of compliance and implementation are not necessarily lawyers, because the question of implementation and compliance really is a matter of relations, international politics. And it's no different at the domestic level, because we also know at the domestic level, courts may issue decisions, judgments, but the executive branch or the state may not comply with them. So it's a problem that speaks to the rule of law, not only at the regional level, but also at the domestic level. So the question, as we'll be discussing in the next session, is how do we encourage, induce, coerce implementation and compliance?
But as I move forward to probably give Dr. Eno an opportunity to speak, looking at the issue of the framework, the monitoring framework you're talking about, which is being considered by the AU, respective organs who are responsible for that, is it like a rekindling commitment? Are state parties rekindling their commitment to say we want to comply with the decisions of the institutions that we've established, and therefore let's go beyond the protocol or the instruments as they exist and come up with something more appropriate or more detailed to regulate or to guide state parties in terms of compliance? Do you look at it as rekindling of that commitment? Why has this happened? It's a good thing, definitely it's a good thing, but probably why has this happened? But before you respond, I want to give Dr. Eno an opportunity to also contribute to the discussion on the subject that we have today. Dr. Eno, are you there? Please make a contribution.
Thank you, Doctor. Thank you, Japhet, and good morning or good afternoon to all participants. I think Japhet has exhaustively and I can say comprehensively spoken with respect to compliance vis-a-vis the judgments or decisions of the court. I see that he focused more on judgments, but there are other decisions of the court that suffer the same fate like judgments. For example, orders or provisional measures, which may be interlocutory proceedings, but may have a very big impact on the rights and duties of parties before the court. You recall that very recently, I think all the, at least the last two countries that withdrew their declaration withdrew because of orders for provisional measures issued by the court. So the court also faces a lot of challenges with respect to enforcement of orders for provisional measures. But I wanted to just touch on some of the issues that maybe due to time, Japhet may not have looked at. And that is challenges facing the court and the implementation of its judgments or decisions. And maybe I should pause here and indicate that the non-implementation of the decisions of the court, in my view, and I should insist that this is my personal view, is becoming one of the greatest challenges to the effectiveness of the court in particular, and maybe the African human rights system as a whole. As Japhet indicated, of the over 90 judgments that the court has delivered on the merits, so far only Burkina Faso has complied with the judgments of the court fully. As indicated also, some states have openly indicated that they will not comply. And they didn't say this to the court. They said it before policy organs of the African Union, the Executive Council, the PRC, and nothing was done. They said it openly, we are not going to comply. And nothing was done. They were not rebuked. No state said anything about it. It just passed like that. So it is becoming, in my view, a very serious challenge, not only to even the raison d'etre of the African court, but the very foundation of the African human rights system. As the quote that Japhet began with indicates, this erodes citizens' confidence in the system. Because if you go to court, you expect that if you win, you are right, you should have remedies. But if the state does not comply, then the confidence in the system is eroded. Let me go now to some of the challenges we face as a court in the implementation of judgments of the court. The first, in my view, is what we've seen as a general lack of understanding of the judgment of the court in particular, or international courts generally. We see a situation where African countries do not take the judgment of the court as a continental judgment. They still see the judgment of the court as a judgment between the parties, that is, it concerns only the country. We've had instances where there has been several judgments of the court dealing with issues of legal aid, dealing with issues of the right to vote, the right to stand in, to participate in government. But we have not seen a situation where other countries that were not involved in the case have used that opportunity to change their laws, to amend their laws, to change their policies, taking into account the judgment of the court. We still see cases coming before the court on issues that have already been dealt with before the court. So we see the situation where there is a general lack of understanding of the impact the judgment of the court should have on the continent. And that is why we are planning to organize sometime next year an international conference on the impact of the judgment of the court, so that it should be understood that when the court delivers a judgment against a particular country, the court has made law for the continent, not only vis-a-vis that particular country. The second challenge we have maybe is the lack of visibility given to the judgment of the court. We know that we have improved in that regard, but we still think there's the judgment of the court is not given as much visibility as it should. And if it were, I'm sure lawyers, judges can invoke the judgments of the court at the domestic level. So we'll continue to work with civil society organizations and through experts like yourselves to see the extent to which the judgments of the court can be publicized as much as possible. The other challenge we have is that we do not get reports from states. Even the compliance by Burkina Faso, it took almost 2 years after the deadline or after the compliance for Burkina Faso to report. It is actually the applicants themselves that informed the court that yes, there has been compliance. So there may be instances where we've had compliance, but states do not file compliance reports. So it makes it difficult for the court to actually have a clearer picture of the compliance situation. So that is another challenge which we are working on. And we hope with the measures that we are putting in place, we are going to overcome some of these challenges. Let me speak, there were some 2 or 3 issues that Japhet raised. I just wanted to clarify them. The first one was the specific compliance report that we prepared with respect to Libya. The practice of the court has been that we just submit a table on the nature of compliance. But with respect to Libya, we were forced because of the exchanges we had with Libya. Libya had reported the court before the Executive Council that they had not received the judgment. At one point, they said, yes, they received the judgment, but it was not in Arabic. So there was some kind of a cat and mouse game that was being played. So the court was forced now to submit a detailed report with timelines on what happened to show to the Executive Council that yes, in fact, Libya had been properly served. We even attached names of those who received the judgments to show to the Executive Council that as a matter of fact, the court had effectively discharged its mandate, its duty with respect to that. So that is why we had a detailed report with respect to Libya. With respect to the framework document on implementation or monitoring of court judgment that Jaffe referred to, yes, it is still a process, and let me also indicate that this was the brainchild or worked on by our moderator, Teresai, and what has happened, the Executive Council adopted a decision that the matter should be taken to the Specialized Technical Committee on Justice and Legal Affairs. We are waiting for the meeting of that committee. We have submitted all the documents. But the one thing I want to draw attention to, I think Jaffe referred to it, is that we are proposing a hybrid process. It is not political, it is not only judicial, but hybrid. And in this framework document, we are adopting what we can also call a persuasive model, in the sense that we have introduced in this framework document the establishment of a human rights trust fund. The human rights trust fund will be used to assist states which are willing to implement the judgments of human rights bodies, but do not have the capacity to do so. That way, through the Human Rights Trust Fund, technical assistance can be provided to them, maybe to review their laws, maybe to engage a consultant to study their legal system, with a view to ensuring that they comply with the judgments of human rights bodies. What we have also introduced is synergy amongst African Union organs, such that if, for example, the Office of the Legal Counsel can provide assistance to a state to enable that state to comply with a court judgment, will engage the Office of the Legal Counsel to do so. If the Department of Political Affairs can provide assistance, we engage the relevant department within the African Union to provide such assistance. So we do not only transmit the judgment, but we work with the state concerned and the relevant African Union institutions to provide the technical assistance to enable the state comply with the judgments of the court. Mr. Moderator, let me end here, but with your permission, I think I can come back where necessary. Thank you, sir.
Thank you, Dr. Eno. So, in fact, I had a couple of questions that I have to put to you, so that when you come back, you just take them into account when you wrap up your comments at the end. My first reaction is in respect of the lack of understanding of court judgments as continental in nature. In the academia, we call that the orientation effect of a judgment, or at least in the European system, they call it the orientation effect, which is exactly what you say. Once the court renders a decision against the state party A on freedom of expression, whatever it says, that decision should be taken into account by other state parties in terms of orienting their laws, their practices around that decision. So I think it's really an international practice that we need to inculcate in our system. But then the question that I have is it not because of phrases such as they must comply in cases in which they are parties? That is in the protocol itself. Is it not? I think it's there in the protocol. It says, and the state party concerned, I'm just paraphrasing, the state party concerned should comply with the decision in which they are parties. It's kind of a universal provision that you find in the European Convention, you also find it in the Inter-American Convention. Does it not undermine this orientation effect that you want to achieve by saying states should orient their laws and practices around a court decision? And then secondly, on states failing to report on compliance, on progress, is it an issue that has been addressed in the new rules? I'm just asking off the cuff. Is it an issue that has been addressed in the new rules? And does the framework also speak to that issue to say what should be done to ensure that states report on progress they are making as far as the implementation is concerned? So please hold on to those questions or those comments that I've made, and you speak to them when we come back. But for now, I want to give a chance to Femi to make their contribution. Femi, would you like to make your contribution now?
Yes, thanks very much for the opportunity. Once again, let me thank our resource person today, Javed and Eno, for a very explanatory presentation. We thank them. My remark really arises on the basis of the comparison Javed tries to make between non-compliance with court judgments at the domestic level as compared to non-compliance at the regional African court level. And I just made the remark, I left it on the chart, that at the domestic level, the litigant or the judgment creditor has the opportunity to initiate contempt proceedings by which senior officers of the state may be jailed, may be sent to prison. It doesn't appear there's anything, any coercive measure at the regional level. Understandably, because state parties are involved. And my concern is the experts that have been involved in the work of the commission and in the work of the court should be concerned really, and they should give us some proposals, some suggestions to go around this problem. Otherwise, there will be no incentive for cases to be brought before the commission or before the court when the fruit of litigation cannot be reaped. Thank you.
Thank you, Femi, for the comments. I would like to give the chance to another person. Zacharias, please, would you like to make a contribution now? Zacharias, Ferosa, Zacharias, please go ahead. Zacharias, are you there? All right, let me go to the question and answer platform, which has a number of questions there. So what I'll simply do is to put them to you, Japhet, and Dr. N, of course, in observation or also listening in case he has some remarks to make later. Will then then keep the question to yourself. We'll take a break. When we come back, we'll go to the next session, and then you answer this together at the end, if that is okay. So I see here a comment from Joint Committee that says, what mechanisms can local government put in place to ensure enforcement of the court and commission orders and provisional measures? It's in the question and answer platform, so you can always check on that. I see another one here from Mutoni Fidel. What is the place of advocacy to engage Africa states for not advancing withdrawal options that can still undermine the court and African Commission independence? So it's talking about, what advocacy, I mean, that's the area, Japhet, advocacy. What lines of, how can we engage African states from an advocacy point of view so that they don't continue with these withdrawal options that can undermine the court and the African Commission's independence. And another one here from Tolmo. I'll wait for the translation, but Dr. Enoch can help us with this one. Just have a look at it and ensure that he's able to speak to it during the second round of questions towards the end. And our support team, the Secretariat, please also assist us with the translation of the questions so that everybody on the platform who is participating is able to contribute to the discussion. So with that, I'd like us to take a break now. It is 1:21. I think let's convene here at 1:30. It's just about 10 minutes from now. Let's take a 10 minutes break and come back to continue at 1:30. At that point, Japhet will move on to look at the compliance mechanism, methods, and initiatives at national level. Here he was talking about regional and international level. In the next session, we'll be talking about national level. And after that presentation, we'll then get into the general discussion session, where questions from the first as well as the second session can be put to the presenter together and be answered. And even further comments can also be made by the participants. So let's take a break now and convene at 1:30. Thank you, and see you shortly. Welcome back. Colleagues, ladies and gentlemen, we'd like to quickly move on to our next, the second and final session of the day. And our presenter is still the same, Dr. Japhet Bigon. He will take us through the second presentation. Thereafter, we'll pose questions to him based on that presentation, as well as those questions we have packed so far that related to the first presentation. We'll look at both sets of questions in the final segment of today's proceedings. So Japhet, please go ahead and let's hear your views on the second leg of your presentation. Thank you.
Thank you, Tarisai. Can you hear me?
Yes, Japhet, I can hear you.
Thank you. So we've just spoken about the mechanisms and
Japhet,
tools that.
Sorry, Jeff, just remember to put your slide in the slideshow mode so that we can see it properly. And of course, just to to speak as slow as you can so that our interpreters are able to effectively interpret for our participants. Thank you. Please go ahead.
Okay, can you see the slide clearly now?
Very clearly, very clearly. Thank you.
Okay, thank you. So we've just spoken about the tools and mechanisms that the court and the commission have deployed to follow up and monitor implementation. This second part of the discussion focuses on what states do when they receive these judgments, or how do they receive these judgments, and what can litigants and civil society do. And I think it might answer some of the questions that we have already had from the first session. So once again, I thought maybe I could begin with a quote. In 2014, in the Journal of Human Rights Quarterly, Rachel Murray, who is one scholar that has really studied the African human rights system, and another colleague, Elizabeth, did a research on national mechanisms on implementation of decisions of the African Commission. And in their concluding remarks, they said that thus far, our research has found that monitoring and follow-up of decisions of the African Commission, and I would guess this also applies to the other two regional bodies, often rely principally on the creativity and commitment of national CSOs and the litigators themselves. Essentially, they are alluding to the point that first and foremost, states are never keen to, as statistics and experience has shown us, are never keen to comply with the decisions of the regional bodies. And when they have done so, it's because of the litigators pushing, CSOs pushing, making the decision and the judgments visible to the wider public, and using a variety of tools to encourage and promote and persuade the state to implement the decision. So first I thought begin with the discussion on state responses. And the first point to note is how that decision is transmitted from the regional body and reaches the office of the relevant person at the domestic level. In ideal setting, in many of the cases, decisions of the commission or the court, I would believe also, are sent through the AU permanent representatives, who are the ambassadors or representatives of the state at the African Union level. And then from the AU permanent representative, the decision is forwarded to the Ministry of Foreign Affairs. From then the Ministry of Foreign Affairs, it then goes, in many cases, to the Department of Justice. Then from there, the relevant departments and bodies that are responsible for implementing a decision are triggered or activated to act. As you can see, this is often a very bureaucratic, long process. And because the Ministry of Foreign Affairs are not really responsible for implementation of many of the cases, if not all, there is almost always a long process that momentum in terms of implementation is lost. And sometimes there is lack of communication between the Ministry of Foreign Affairs and the Ministry of Justice, and then between the Ministry of Justice and the other institutions that are responsible for implementing that decision. Because in many cases, you might find that a decision of the commission or court requires synergy and collaboration or the expertise or resources of different departments of the state. And therefore, if that process is not followed keenly, then implementation may not occur. And it's actually for this reason that the court, in its proposed framework, is suggesting that the state actually appoints a focal point that will be responsible for engagement with the court. Otherwise, a loss of communication will be the result. And as Dr. Eno really clearly said, you can see even in the instance where there was full compliance, still there was no communication in the case of Burkina Faso. And it's only the complainant that brought to the attention of the court that the case has been complied with. But across the continent, we see there are certain states that are taking measures or have put in place mechanisms for reception of decisions from the regional bodies. And this does not necessarily speak to the effectiveness of those mechanisms, but at least they exist. And one, of course, is Cameroon, which has a Department of Human Rights and International Cooperation within the Ministry of Justice established in 2005. This department is responsible for receiving those decisions from the regional bodies. And I would imagine that, for instance, in the recent case, Genevieve versus Cameroon, which the Commission has said has been fully complied, then this department might have played a role. And this is not the first time that Cameroon is reporting. It has also reported previously in the Gunme case. And you can see when there is a dedicated department within the Ministry of Justice that is responsible for reception, then the likelihood of reporting increases. And in the case of Cameroon, they usually release an annual report on the state of human rights in Cameroon. And in that report, they have a chapter that focuses on cooperation with international human rights. And if you go back to some of the editions, you will find where they actually even list challenges to implementation of decisions of international courts and tribunals. So such a department, I know also recently, Malawi, for instance, has also a department that is responsible for engagement with the regional bodies. And you can see, since the activation of this department, Malawi has become an active actor, at least at the African Commission, where now they attend sessions and reports are submitted. But then it's yet to be tested in the case of a decision and its effectiveness. I know Kenya has also recently established an interministerial committee that is responsible for developing all its reports that are submitted to regional and international human rights bodies. Unfortunately, reading through the terms of reference, it does not include reception and coordinating implementation of decisions from these regional and international courts. But again, also Kenya has come up with this unique mechanism, if controversial, where in the two cases, the Endorois decision from the African Commission and the Ogiek decision from the African Court, in both cases, Kenya has established a task force responsible for studying the decisions or the judgment, and then coming up with mechanisms for implementing it. Now, this is, on the face of it, looks a very good process of receiving and triggering the process of implementation of the decisions. But critics have looked into the membership, into the terms of reference of these task forces, and they have raised serious concerns. One, of course, has been that in both task forces, the victims, the complainants, the communities that brought the cases before the bodies were not represented. But also, reading through the terms of reference, it was almost seeking a reinterpretation of the orders or the decisions of the commission and the court. But also, critics, for instance, have argued that historically, Kenya has used task forces, commissions of inquiry to really bury matters of concern. They simply act as smoke screens for diffusing public criticism, so that you see that we have established a task force, the government will say we've established a task force, we are looking onto it, and therefore the pressure on it to implement the decision is deflected or diffused. And it's no wonder that in both cases, we have seen actually continuous violations of the rights of the Endorois and Ogiek. It's despite the fact that the government has established task forces to implement these decisions. But on the face of it, this will be one good way where a government establishes a specific mechanism for reception and coordinating implementation of decisions from these regional bodies. Other governments, Tanzania, Cote d'Ivoire, have, for instance, gone back to the court to ask for interpretation of the judgments or the orders. In one instance, the concerned in the relation to Tanzania, the Tanzanian government was not really sure whether the court had asked it to release the individuals, that their right to fair trial had been violated, or what really should be done. And they went back to the court for interpretation of the judgment, a procedure that is provided for within the African Court Protocol. And then Cote d'Ivoire, also in the case that concerned its independent election body, went back to the court. Although in this Cote d'Ivoire Ivorian situation, it was really not clear whether that request for interpretation was really necessary, because the decision of the court really looked was very clear, and it seems Ivory Coast was simply delaying the process of implementation. But requesting for interpretation is one process that can actually show step towards and willingness to implement a decision that we want to implement, but we do not understand clearly what we should do. And then the court would offer much more advice and clarity into the issue. But as we began this discussion, it's not always the case that states would comply. So what would be the role of litigators and civil society, and what has worked and not worked in practice? It is important that CSOs and litigators engage. One is to increase the likelihood of implementation. If the decision is not followed back to the domestic level and pressure put on the state and visibility brought to the decision, then non-compliance is more likely. So it's always, if litigators and CSOs engage, they will increase the likelihood of implementation. But also, your role would include to verify and ensure accurate information is provided by the state to the regional body that is concerned. Because this is even in the new framework is envisaged that there might be a dispute as to the extent to which compliance or implementation has taken place, and whether the complainant has been satisfied by the actions of the state in terms of implementation. So it's important to engage so that you can provide to the court, to the commission, accurate and verifiable information. And as I said earlier, Rule 81 of the court, Rules 2020, provide for the court the power, the mandate to collect information from a variety of actors. The same applies to the new rules of procedure of the commission. And also to provide publicity and increase awareness of the decision. If the decision is not known publicly to a variety of actors who can be able to push the state to act, then it's easy that non-compliance is more likely. And then finally, to ensure a victim-centered approach to implementation. It's easy that the victim can easily be forgotten in the state. Like I've said, in the task forces established in Kenya, victims have not been given representation or even allowed to participate more actively as they should. So when litigators, CSOs engage, then you can try and push and advocate for a more victim-centered approach to implementation. But then what are the tools that can be deployed to ensure that at least the state takes the path towards implementation? The first, whenever possible, is to encourage the state or advocate for the state to adopt an action plan in terms of implementation. This is pretty easy where the decisions are not many decisions. For instance, in the case of Tanzania, if it is one or two decisions, then it's possible for the state to adopt an action plan for implementation. And the action plan can do 4 things. One is to identify the relevant departments responsible for implementing the specific decision. And then 2 is to set the time frame for implementation, taking into account the time that it has been given by the court or the commission. So in the case of the commission, that will be 180 days. So to prepare a timetable of implementation that will ensure that implementation occurs within the 180 days, or if not, but then that there will be something to report at the end of 180 days. Then thirdly, to map the skills and resources that are needed for implementation. And then finally, to identify areas of collaboration with CSOs and other stakeholders. In future, for instance, in terms of mapping skills and resources needed for implementation, you'll recall that Dr. Eno has said that there will be possibly a fund that can help states to implement decisions, acquire necessary skills, technical help that they would need. So that process of mapping the resources and skills will be important in deciding whether you need the help of this fund in the process of implementation. Then sensitization workshops. Hold workshops to evaluate status of implementation and develop advocacy strategy. One of the cases that has really gained a lot of publicity and a lot of implementation activities is the Endorois decision, and which litigants and the victims have engaged in a lot of publicity activities that raise the profile of the case at the domestic level, but also at the international level. So for instance, in the Endorois decision and also in the Ogek decision, the day after the decision were issued, these communities organized huge celebrations that really put the spotlight and the media coverage of the decision, and became a national discussion within the country on the extent, on the future of these communities in terms of their right. So it really transplants the decision from the regional level to the domestic level and makes it a national discourse and conversation. Then finally, not necessarily finally, but thirdly, it's almost always the case that we focus much on the executive branch because it is the one responsible for implementing the decision in the end. And in certain instances, Parliament might also be involved if reform of laws are needed. But if reform of laws are not needed, it's also good to alert and engage with the relevant parliamentary committee or parliament as a whole about the decision, update them on the status of implementation, but more importantly, ask the relevant parliamentary committee to exercise its oversight role over the executive branch and ask the executive branch the extent to which it has implemented a decision. So this has happened, for instance, in the Enderois decision where a member of parliament put a question to the Ministry of Lands on the implementation of the Enderois decision. And the government was put on the spotlight to explain to what extent it has implemented that decision. Then national human rights institutions have a very specific role in terms of implementation under at least the 2020 rules of procedure of the African Commission. NHRIs as state bodies that are responsible for promoting and protecting human rights, and also in many instances are also responsible for monitoring the extent to which the state is complying with its international human rights obligations, which would extend to complying and implementing decisions. So it's good to also engage the NHRI. In the case of the Enderois decision, NHRI was part of the task force, but also monitoring what the state is doing and reporting on the extent to which the state has complied. And here I should pause and mention that NANRI, the Network of African National Human Rights Institutions, have established guidelines for NHRIs on what they can do to promote, facilitate implementation at the domestic level. So it will be good as an advocate, as a litigator, as a CSO, to carry with you or use these guidelines as a reference point when engaging the NHRI in relation to implementation. But also the legal profession should be important. Bar associations, both at the domestic level, but also at the regional or sub-regional level. Good to know, it's good to alert them that this decision has come out from the court or from the commission or from the committee, and ask them for their support in terms of pushing for implementation. And then finally, second last is media and communication. Raising awareness. I think publicity is always a good pressure point for states to act. And this is connecting publicity, not just at the domestic level, but also at the regional and the international level, and bringing the case to actors beyond the state, but those that have influence on the executive branch of the government. And here it's important to adopt a media strategy or a communication strategy that lays out what needs to be done when, for instance, during the first anniversary of the issuance of a decision, it is often good to create some buzz around that first anniversary of that decision, taking stock of what has been done since the decision was issued. Then finally, and this is really long-term part of the advocacy and may not serve the single case that you are working on, but long-term, the aim should be to encourage government to establish legal framework for reception of decisions from international courts. This has been a long discussion amongst scholars. For instance, some have argued that in Commonwealth countries, the reciprocal judgment procedures should be used for executing of judgments or decisions of international courts. The jury is still out whether this is applicable, but we have seen in certain instances like the SADC Tribunal, the legal framework in South Africa being used to execute an order of the SADC Tribunal, of course, with the disastrous consequences leading to the suspension of the SADC Tribunal. But the point here is that it's important to create I would advocate for governments to establish legal framework or be aware that decisions of the court of regional international bodies need a mechanism at the domestic level for their reception and implementation. I think I will stop there and then take questions beginning from what we discussed in this first session to this second session. Thank you, Tarisai, over to you.
Thank you, Japhet, for the presentation, and of course raising new issues that I think panelists, participants were able to reflect on and pose some questions or some comments or contributions to the discussion. So for me, I'm hearing that there seems to be a regional level and a national level, of course, working together, but in a way, some monitoring of compliance or some efforts to seek to influence the compliance process at regional level as well as at national level. And I think that you were very clear when you spoke about the regional level to enumerate the institutions, the organs, at least in the African Union, in the African human rights system, the organs responsible for that, including the court and the commission themselves, as part and parcel of the institutions with competence, or at least a practice, to ensure that they're able to to monitor compliance as well as to report on compliance itself. But when we went to the national level, there are even more actors there, and I think that the conveners of this workshop have been really vindicated by focusing on legal practitioners, on CSOs at national level, and I think that even the participation also extends to some officials from national human rights institutions who are participating in this online training, to say you have a specific role to play at the national level to influence implementation of decisions of the court, as well as decisions of or recommendations of the African Commission on Human and People's Rights. And that's exactly what we wanted, this particular online training to do, to bring that awareness, to improve that awareness, that knowledge of what is it that we actually supposed to be doing as a legal practitioner, as a litigator, or as a bar association, or as a CSO, or a coalition of CSOs, and so forth, and national human institutions. So there are so many, even as the judiciary, we've been talking about using the foreign judgments procedure to implement decisions of regional bodies like the African Commission. So the judiciary is part of that process, to say as the judiciary also part of the process. Or even as parliament, it's part of that process, because if it has to come up with a law that receives formally international decisions, then there has to be a law, and definitely parliament will take. So everybody at the regional or national level, they have a role to play. The media, as Dr. Eno said, publicizing judgments. At the role of the media to say there's an Android decision, publicize it among communities, and so on and so on. So I think each one of us has a specific role to play, and this training is really bringing us to that awareness of what role we can play. I see Caroline has a hand up. Would you like to make a contribution now, Caroline?
Yes, please. Are you getting me?
Yes, please go ahead.
Okay, I wish to thank the presenter for his eloquent presentation. And my question is on compliance, and following the adage that justice delayed is justice denied. I was just wondering, what is stopping the African court from coming out with a uniform executory order, or to ease the challenges that comes out with compliance?
Mm-hmm.
Hello.
Yes, Caroline, are you done with your contribution?
Yeah, that is my contribution. What I'm saying is I'm wondering what is stopping the African court from coming out with a uniform executory formula to ease the challenges that comes along with compliance.
Thank you for your question. I think Japheth will speak to it, and of course, Dr. N is on standby to also, give us some internal dynamics, on some of our, the approaches or the methods of work of the court, in particular to the question that Caroline has put across. Carlos, would you like to make a contribution, please? Carlos? Carlos, your hand is up. Would you like to make a contribution now? Okay, we'll come back to Carlos when they are ready to make their contribution. I think there are a couple of, yes. Carlos, is that Carlos or someone else? Yes, Carlos, go ahead, please.
Allô?
Yes, go ahead, Carlos. We can hear you now.
Ok, bonjour la grande équipe. Je suis très content de savoir l'évolution du cours aujourd'hui, mais je voulais participer par rapport à une intervention en ce qui concerne l'applicabilité ou la mise en œuvre des décisions de la Cour, ici au niveau régional et aussi particulièrement en République démocratique du Congo, où je suis un demeurant. Alors, il y a des propositions que nous voulons, n'est-ce pas, amener à la Cour. C'est qu'il faudrait qu'on puisse, n'est-ce pas, avoir la possibilité de dater demain les personnes qui sont mises en cause dans une décision de justice. À l'exemple, si nous avons quelqu'un qui a été appelé en République démocratique du Congo, par exemple ici, qui a affaire aux droits de l'homme, qui a affaire à une question que la Cour devait gérer et que nous avons besoin que cette décision puisse s'appliquer effectivement ici en République démocratique du Congo, il faudrait que la Cour puisse prendre en compte les règles d'applicabilité qui existent déjà dans le pays qui est attaché à la personne qui est effectivement poursuivie devant la Cour. C'est que cela veut dire que cette décision, n'est-ce pas, elle ne sera pas une décision étrangère aux dispositions applicables déjà en République démocratique du Congo et que ce sera effectivement une décision qui amène un élément d'extranéité parce que c'est une décision qui a été prise de l'extérieur et que de là, ça ferait la possibilité de pouvoir la faire appliquer, n'est-ce pas, d'une manière effective. Ça, c'est le premier point. Le deuxième point, il est relatif au fait que les décisions qui doivent être prises de l'autre côté, ici, chez nous, en République démocratique du Congo, par exemple, nous aimerions beaucoup plus que pour la mise en œuvre de ces décisions, que nous puissions voir l'effectivité sur le terrain du droit de l'homme. En fait, le droit de l'homme, ici, je suis en train de vous parler en ma qualité de juriste, avocat, des métiers. Le droit de l'homme, on ne le comprend pas de la même manière qu'on comprendrait la procédure pénale au niveau de l'international. C'est-à-dire, la procédure pénale ici, elle a la possibilité d'être appliquée parce qu'elle a été prise par les institutions et elle est prise en compte. Mais tandis que les droits de l'homme, nous avons plus l'impression de croire que ce sont les ASBL, alors qu'une ASBL, c'est que naturellement, elle n'a rien à faire, rien à voir avec ce qui se passe au niveau judiciaire. C'est que c'est une institution qui est, comme on les appelle, hors État et que c'est une institution qui n'est pas prise en compte par les systèmes judiciaires congolais. Donc, dorénavant, il faudrait que la Cour puisse avoir la possibilité de faire appliquer, ici au Congo, la possibilité de faire appliquer quoi, voilà, disons, les ASBL, par exemple, les ASBL devaient avoir plus de force. Ça ne devait pas être considéré comme étant, des acteurs qui sont extérieurs ou privés. Non. Comme c'est une question aussi d'extranéité qui compte, du fait qu'une décision est prise de l'extérieur. Et nous pensons que, à ce moment, de ce point de vue, par rapport au cours qui vient d'être donné ici, c'est un avis certainement, que nous voulons assez que la Cour africaine puisse prendre en compte ces éléments. Quant à ce qui concerne la question, moi je voulais poser directement la question, quel est l'endroit idéal, ici par exemple en République démocratique du Congo, où je peux demander à ce qu'on puisse exécuter la décision de la Cour africaine des droits de l'homme. Merci beaucoup. Voilà l'intervention avec laquelle je voulais intervenir à ce jour. Merci pour la parole.
Thank you. Thank you for the contribution. And I see, yes, I do not have any other hand that is up. Let me go to, I see the panelists there. Okay, I'll get to Dr. N. I'll give you a chance just now. I am looking at the chat box. There are a couple of questions there. The first one is saying, it's a question and contribution coming from our colleague Tolmo, who is a regular contributor in these discussions. He says, several obstacles to effective judicial review of human rights in Africa are conceivable. They are either of a legal nature, the direct access of individuals and NGOs to the court, or the difficult acceptance of states to comply with the court's decisions, or of a factual nature, such as ruthless poverty. The question now is, what do you see as the future of the court between now and 2070? Is it another 50 years to come, half a century to come? So Dr. Eno and Japheth, you can look in the chat box so that you can better understand the question. So the participant goes on to say, when will the new African Court of Justice and Human Rights arrive? Utopia or equality? When will the new African Court of Justice and Human Rights arrive? Utopia or equality? He goes on to say, to ask, do you think that the linguistic dimension of the court's English-speaking character is a handicap to its effectiveness? Do you think that the linguistic dimension of the court's speaking character is a handicap to its effectiveness? I say utopia or reality. And I'm glad that Dr. Eno is here to address the questions such as these. I think he did this before in our first session or second session. A similar question was put to the panelists, and he was able to assist us in terms of clarifying some views people may have across the continent as far as their institutions are concerned. And then there's a question from DI that says, does it happen in the country visits to meet the actors of justice of the countries to ensure a dialogue with the national judges? Does it happen in the country visits to meet the actors of justice of the countries to ensure a dialogue with national judges? So the country visits you're talking about, the chance to meet with national judges, or is there an opportunity for dialogue with national judges? He goes on to say there is an impression that national judges are reluctant to the compliance of regional courts. So do you at least have interventions in the training or in a collaboration to make known the positions of the court by the national judges? Yes, so I personally do share the same impression or the same view with Ndiaye there, that national judges seem to be reluctant to participate in the, especially in receiving decisions of of regional tribunals or courts, such as the African Court, to receive them in their domestic legal order, recognize them for purposes of enforcement or implementation. They seem to feel in some cases that it's a fight over jurisdiction. How can another court elsewhere bring a judgment in our system and expect us to do so? You know, they seem to be more willing to do so or to receive foreign decisions if they're coming from judges of another country, following, you know, the legal framework that regulates that process. But these regional courts seem to be a bit new to the foreign judgments procedures that we are aware of. I think that the SADC Tribunal, before it was disbanded, it was one of those institutions whose rules of procedure allowed enforcement of its decisions using the foreign judgment procedure. Maybe in the Americas as well, there's a bit of that practice, recognition of financial decisions as applicable at national level, even after they've been rendered by international or regional courts. So they're just, you know, some of the questions that are coming through. From Kone, the contribution is, I have one concern. I believe that it is a matter of bad faith or even lack of political will on the part of member states. I believe that no state has been obliged to sign or ratify regional, sub-regional, or international agreements. So I think it's the contributor is making the view that there seems to be bad faith, lack of good faith by states, lack of political will by states, yet they ratified these regional, international, and sub-regional instruments or agreements voluntarily. But when it comes to implementing those agreements, now they are reneging from that obligation. And then another contribution says, now why are they having trouble implementing the decision of the African Court? So I think the continuation from Kone's contribution. Now why are they, state parties, I think, having trouble implementing the decisions of the African Court? Why undertake advocacy first or negotiate with states before they implement the court's decision? For my part, it is lack of respect and devaluation of the court by member states. So as you know, Dr. N has also been saying, non-compliance at national or regional, international level, it undermines the institution that renders the decision. So Connor is making the same sentiments there to say, why even negotiate with the state party before it implements? On his part, it is a lack of respect and devaluation of the court by member states. This is what we have in the chat box for now. I don't see any further hands except that of Dr. Eno. Probably as Japheth catches up with his breath out of the presentation, I would give the opportunity to Dr. Eno probably to go first and speak to questions that have been put across by participants as Japheth. Then Japheth will also come after that. If there's another round of questions, we'll take another round of questions and see how far we go. Dr. Eno, you have the floor now. Thank you.
Thank you, Daresai. Let me start by making 2 points. The first one is that respect for human rights and the implementation of judgments of be it national or international courts is the responsibility of member states. And it is a member state that has to put in place appropriate mechanisms to ensure that court decisions are implemented. The second point I want to make is that we note some kind of a disconnect between domestic decisions and decisions from international tribunals. And what should be established, I'm sure Japheth may want to speak to this, and even other participants may want to speak to this, is what is the status of judgments of international tribunals like the African Court? Is it a foreign judgment, or should it have a direct implementation force as a domestic decision? If you allow me, Mr. Moderator, I'll read for you the provisions of other regional courts in this area. For example, I think this should be, I'll just deal with courts in the region. The East African Court, for example, Article 44 of the treaty establishing the East African Community says that the execution of a judgment of the court which imposes a pecuniary obligation on a person shall be governed by the rules of civil procedure in force in the partner state. The order for execution shall be appended to the judgment of the court, which shall require only the verification of the authenticity of the judgment by the registrar, whereupon the party in whose favor execution is to take place may proceed to execute the judgment. So, although this is with respect to judgments with pecuniary obligation, because the treaty is silent with respect to judgments that do not have pecuniary obligation, I would assume it will be the same procedure. So there is an execution order attached to the judgment, which makes it enforceable directly upon being authenticated by the registrar at the domestic level. So that is a provision in the East African Court of Justice. If we look at the Ecowas Community Court of Justice, it also provides for, under the Ecowas Protocol, Article 24, that execution of any decision of the court shall be in the form of a writ of execution, which shall be submitted to the registrar of the court to the relevant member state for execution, according to the rules of procedure of that member state. Upon the verification of the appointed authority of the recipient member state that the writ is from the ECOWAS court, the writ shall be enforced. So again, it deals with direct enforceability. It doesn't need to go through the procedure of foreign judgment procedure. The SADC Tribunal, which Tarisai talked about, has some kind of similar provision. It provides that that the law and rules of procedure applicable for the registration and enforcement of foreign judgments in the state in which the judgment is to be enforced shall apply. So the SADC Tribunal brings in the idea of foreign judgment. This is the only regional provision which invokes the rules of procedure or of foreign judgment. But it goes further to say decisions of the tribunal shall be binding and enforceable within the territories of the state concerned. Unfortunately, the African Court Protocol nor the rules make provision for how the judgment of the court will be enforced at the domestic level. So if we agree that the judgment of the African court is not foreign judgment, but rather judgment that should be implemented directly, then we have passed the first hurdle. What simply needs to happen is that we put in place mechanisms like, for example, the East African Court has done or the Ecowas Court has done to ensure that we just attach to the judgment of the African Court writs of execution for it now to be authenticated at the domestic level for implementation to take place. We do not have that yet. There was a question asked by, I don't know, I've forgotten the name, by one of the participants, that what is stopping the court from coming up with a uniform executory order to deal with compliance? This is one issue that can be explored further. But in my view, this cannot be done by the court itself. I think it needs some kind of a treaty to be adopted at the policy level of the African Union. It needs that all the member states agree on the way in which the judgment of the court can have direct execution at the domestic level. What we have done, however, we've written to all the states, state parties to the protocol, to appoint focal points that will work directly with the African court, so that if we have any decision against a particular country, we send to that focal point, and we should be able to write to that focal point to follow up on execution. Some states have supplied names of their focal points, most of them from the Ministry of Justice, some from Foreign Affairs, but we do not have that for all the states. But even if we did, the question will be whether those focal points can actually push with the enforcement of the judgments of the court, or whether we need, as somebody has proposed, a uniform law, a model law that all the states will agree that this is how the judgments of the court can be enforced. Before the break, Mr. Moderator, there were some questions that you had raised, which, with your permission, I would like to speak to them. One is, maybe I'll leave this to the keynote speaker because this is his show. But let me just speak to some of them that deal directly with the African court. There was a question about the linguistic character of the court. This issue came up during the last module, and I indicated that it is unfortunate that there's an impression that the court leans more towards the English extraction. Unfortunately, this is a wrong impression, because even if you look at the current composition of the judges, we have 6 French-speaking judges and 5 English-speaking judges. Even in terms of staff, I think there are more French-speaking than English-speaking. The current president is Francophone. Of course, I'm Anglophone, but the deputy registrar is Francophone. So I think it's a wrong impression, but the linguistic composition notwithstanding, I don't think that has anything to do with the effectiveness of the court. It does not affect the work of the court at all. In any case, we have 4 official languages, and all our sessions are conducted with simultaneous interpretation in Arabic, English, French, and Portuguese. So the language does not affect the work of the court. It may retard the work of the court in terms of translation, but it is very minimal. There was another question from Abdullah Ndiaye whether the visits that are undertaken, we engage with national judges, and there's a reluctance from national judges to implement judgments of regional courts. And he wants to know if there's any initiative of intervention in terms of training in this regard. Yes, we have undertaken a lot of sensitization. And as judges, when the judges go for any visit, the Chief Justice is always, in almost all, I can say in all the visits, the Chief Justice is always one of the high-level personality to be visited. In some cases, meetings have been held with the judges of the states visited. And in some cases, judges have been invited to a sensitization seminar, which is always organized during such visits. But apart from that, the African Court organizes every 2 years what we call a judicial dialogue, a dialogue between the African Court and the national judiciaries. And this dialogue brings together chief justices, presidents of constitutional courts of all African Union member states, including sub-regional courts like Ecowas and East African Court of Justice. And during such dialogues, quite a number of issues are discussed, including implementation of judgments of the court. Yes, in some of these dialogues, this reticence, this reluctance have been expressed, but I think with more dialogue, there will be the opening up and acceptance of the necessity to accept the judgments of the court and even to cite them. I understand some of the judgments of the African Court were cited by judges in Lesotho. And that is a kind of thing that we want to see the judicial dialogue produce. The other thing, Mr. Moderator, is that we have, in collaboration with the national judiciaries, we are going to be launching an online human rights course for national judiciaries, where national judges at the domestic level will be taken through the African human rights system, international human rights law, so that they also come to understand the relationship between human rights at the domestic level and the international human rights system, and how they can work together to for the effective protection of human rights. So yes, measures are being put in place to encourage this to happen. But Teresa, let me end with the question that you asked yourself with respect to Article 30. You wanted to know whether Article 30 does not require, is not a hindrance in itself, that judgments of international tribunal or of the African Court should be complied with by the states concerned. I think that article is okay, because only the states concerned in the case before the court can comply with a particular judgment. For example, if the judgment of the court is to the effect that reparation should be paid, you do not expect another state that was not part of that case to pay reparations. However, when the court interprets a particular provision of the African Charter to which other states are parties, it means that that interpretation binds those states that are parties to that particular convention. And to that end, those states need to look into their laws to ensure that their laws are amended in a way that is in conformity with the interpretation given by the court. So it is different. It is different from compliance. This is to take measures to ensure that you bring your laws in conformity with what I can say, for lack of a better word, the law that has been created by the interpretation given by the court for that particular issue. So I thought I should make that distinction. So with that, my dear brother, I rest my case, but if you want me, I'll come back. Thank you, sir.
Thank you, Doc, for always useful and very helpful clarifications and articulation of the law in practice and in the text. And so, as we are speaking about the direct application of judgments of the court at national, I agree with your interpretation there to say it's one thing to talk of direct application of decisions of the African court or other regional courts at the national level, and as one avenue of implementation. And then the foreign judgment procedure, which you correctly pointed out to say it's clearly provided for in the rules of procedure of the SADC Tribunal, implicates the foreign judgments procedure. But before then, he had posed a question to say, how do we characterize decisions of Ecowas Court or the East African Court of Justice? Are these courts foreign courts for purposes of enforcement? And I agree with you. If you go through many pieces of legislation of many African countries, they don't easily qualify as foreign judgments, because historically a foreign court is a court established by the law of another state and it's resident there, manned by judges of that country. But when you look at a regional court now, it's a different court. Yes, it's resident in a state somewhere, but its characterization is that it is national, international or regional in nature. But then, when I was doing some research on this, I stumbled upon a piece of legislation from where I am here. There's a piece of legislation called the Civil Matters Mutual Assistance Act. And surprisingly, it actually makes reference to decisions of international tribunals. So it already makes reference to that, where it says an international tribunal means any court or tribunal which, in the pursuance of any international agreement or any resolution of the General Assembly of the United Nations, it exercises jurisdiction or performs any function of a judicial nature or by way of arbitration, conciliation, inquiry, etc. I was just enthused to see that at least some pieces of legislation already make reference to international tribunals as part of a class of courts or tribunals whose decisions could be actually recognized using the foreign judgment procedure. But I think that countries are at different levels in terms of this kind of recognition. So for those who are researching around this area, it could be a piece of legislation that you want to have a look at and see how it probably can be a solution to the problem of implementation of decisions at national level. And this discussion, Dr. Eno, clearly shows that as lawyers at national level, we have a clear role that, look, if you have a client who got a decision in their favor from the African court and the state is just mum, it's not doing anything to implement the decision, you may be proactive in your approach to say, can we not approach national courts and seek enforcement or execution of this particular decision of the African court through the national judiciary? Just do it and see what happens. I remember here in Zimbabwe, that decision from the SADC Tribunal was actually taken to the courts, and the courts accepted it as a foreign decision. But of course, it did not go through on the basis of other grounds. There's a checklist of requirements that need to be met. So if it doesn't meet one of those requirements, then you've got problems of it being accepted at national level. But at this point, let me allow Japheth to come in and address some of the questions that pertain to this session or the earlier session, so that we know that we have cleared the backlog of the questions that we had shelved to allow you to go through your second presentation. Japheth, please respond to the questions and comments. Thank you.
Thank you, Tarisai. I think to begin with, maybe to pick up where Dr. Robert Eno ended, and this is in regard to the broader orientation effects of the decisions. I think the drafters of the African Court Protocol also envisaged that parties to the African Court Protocol, although not directly impacted by a decision, would also take measures to change their laws if necessary. So for instance, the Rajabu Ali versus Tanzania case on death penalty, and where the court held that mandatory death sentences really are a violation of the right to fair trial and the right to life under Article 4 of the African Charter. So you would presume that although the case concerned Tanzania, then other countries with similar laws, and because most of these laws were borrowed from the colonial masters, it's likely that there are other countries with similar laws that provide for mandatory death sentences in certain offenses, would consider this judgment and change their laws because the court has said that they're in violation of the right to fair trial. And when I say the drafters really did think about somehow about this, even if implicitly, you'll find it in Article 29 of the African Court Protocol. It says that the parties to the case shall be notified of the judgment of the court, and it shall be transmitted to the member states of the OAU and the Commission. For what reason would the court transmit the judgment to other members of the OAU, if not to tell them that this is the interpretation on these particular issues, and therefore change your behavior to conform to this this interpretation of the charter? So I think actually it was really envisaged that the judgments of the court will have broader orientation effects to state parties and AU member states in general. Then secondly, I want to add, you asked a question at the last session about whether this move by the Executive Council to have the court to develop a framework for reporting and execution really is a rekindling of their commitment to implementation and human rights. On the one hand, we can say in principle it does. It shows that there is consciousness and awareness that implementation matters and that decisions of regional bodies should be implemented. And actually, if you go and read through almost each and every decision of the Executive Council, you will find the Executive Council imploring members to comply with the decisions. But there is always a big gap, a big chasm between the rhetoric of the Executive Council and its practice in reality. So as I said during my presentation, on the one hand, it encourages members to implement. On the other hand, when the court says that so and so has not complied, the Executive Council turns back and says, no, we cannot mention that in our decision. So it shows that there is rhetoric and a difference in rhetoric and practice, that in many instances, the Executive Council engages in rhetoric, perhaps because in those discussions, it's perhaps the louder states that take the floor and their say becomes the way. Nevertheless, the fact that they are pushing the system towards a framework, for instance, always becomes important and becomes a tool for holding them to account. Whether they are doing it in rhetoric, without good faith, in the end, civil society, litigators, other states can use that same language that they have used or the framework that they have called for to hold them to account. So it's not completely, it should not be lost to us that this can still be used for actually to be used to put everything in good use. Then Femi made a comment that I completely agree with. Although I tried to make a comparison between the national and the regional international level, there are always obvious differences, including what Femi referred to, that at the domestic level, there is the contempt of court proceedings that can be used to punish individuals who have not complied with court decisions. This, of course, is not available at the regional level, although at the East African Court of Justice, contempt of court proceedings has, at least in one case, been brought and successfully litigated. But this is not applicable to the regional bodies that we are speaking about here. But I must mention that actually, Article 23 of the Constitutive Act provides for sanctions against member states that do not comply with the decisions of the African Union. And if we consider the court and the commission, the committee as part of the ecosystem of the African Union, one would imagine that Article 23, for instance, will be used as a sanctions regime for non-compliance with the decisions of the regional bodies. Of course, the reality is quite different. The only area where we have seen the African Union imposing sanctions is in relation to unconstitutional changes of government, and as recently as Mali, but not in any other areas. There has been recent suspension or threat to suspend South Sudan from participation in meetings for non-payment of their dues to the African Union. Those are perhaps the only two scenarios where we see the African Union using its sanctions regime. Ordinarily, this sanctions regime should extend even to decisions, orders, and judgments of the regional bodies. But the African Union has not been effective in that regard.
How about, before you move on, this aspect of the incentive approach, I would call it that way, where Dr. Eno spoke about the funds, some funds may be available, some technical support. I'll look at it as incentives, like an incentive approach to compliance, really, to trigger compliance. Do you think that it's an alternative that could probably be dangled, a carrot being dangled to member states to really come to the party in terms of feeling obliged to comply because there's this technical support and some other forms of support available to them?
I think it does. I think it pushes the state to a corner, because in many instances, the state will say, this judgment, we are not able to comply with it because we do not have the capacity and all that. But if the court can be able to come back and say, see, we have this technical support and we are going to provide for you, or the Office of the Legal Counsel at the African Union has this capacity that it can help you to comply with the decision, then we reduce the excuses that the state can have for non-compliance. So I think an incentive approach, as you say, can play a role in pushing the state towards complying with the decisions of the court. So I would agree with Eno that this can actually contribute to that process.
So please go ahead with the rest of your questions.
Yeah, so Carlos from DRC Congo had asked about where he can get information about the compliance rate of DRC, of decisions of the regional bodies. I'm not sure I'm capable to advise on this, but from trends and patterns across the continent is that decisions, really implementation is almost always coordinated by the Ministry of Justice. So while the Ministry of Foreign Affairs receives the decision, it is then forwarded to the Ministry of Justice. Then perhaps the first port of call will be the Ministry of Justice to ask it about the extent of implementation, but also to link with the complainants and the litigators in that case, I think would also be a good starting point in terms of getting that kind of information. Someone did ask, I think it might be Tolmo or someone else, about the African Court of Justice and Human Rights, whether it will ever see the light of day. I'm not able to say whether it will see the light of day, but I can give you some background on where things stand currently. As you know, the African Court of Justice and Human Rights Protocol was adopted in 2008. As we speak today, only 8 states have ratified it, and it needs 15 ratifications to come into force. So we still need 7 more states to ratify that treaty. And if I'm not wrong, I think Angola might have ratified the treaty in May or April this year. I heard the state representative of Angola saying so during the recent 66th ordinary session of the African Commission. So the number might have risen to 9 as we speak today. But the story is more complicated than that, because in 2014, the African Union adopted the Malabo Protocol. The Malabo Protocol makes amendments to the 2008 Merger Protocol, and it introduces a criminal chamber and that will form part of the bigger African Court of Justice and Human Rights with 3 chambers: a chamber for human rights, a chamber for criminal jurisdiction, and a chamber for state disputes, international law disputes. This Malabo, what has come to be known as Malabo Protocol, has not been ratified by any country, and it has 15 signatures. So there are 2 different protocols. When we speak about the African Court of Justice, there are 2 different protocols that are in play, and depending on which comes in force earlier than the other, then the court will be established in that manner. But in terms of the Malabo Protocol, there's been a lot of qualms, a lot of controversies because of the criminal jurisdiction that it has, and especially a provision in that protocol that provides for immunity for heads of state and senior state officials from the jurisdiction or even investigations by the court. So I know South Africa, for instance, has put it on the table that they would wish for that protocol to be amended again. So the likelihood of the African Court of Justice and Human Rights seeing the light of day in the near future is unlikely. But the African Union also has a capacity to shock. So within a few years or a few months, it will not be surprising to see 15 ratifications of either the 2008 protocol or the 2014 protocol. But that is where things stand currently. Then Dr. Eno already spoke about the court visits and when they meet judges. The African Commission also conducts country visits where sometimes issues of implementations are discussed, as I said. I'm not sure whether they always meet judges, but I know they usually meet relevant actors who are involved in implementation of certain decisions, as they have done in Botswana, in Kenya, and in other countries. I think the question of the status of judgments of the decisions have been dealt with pretty well. So that perhaps I think are all the questions that were still pending, Tarsai.
Mm-hmm. Thank you, Japhet. I see another question here in the chat box, and it says, there's a question from Prisky. It says, I would like to come back to the choice of focal points by member states. Do you think it would be effective or better for member states to designate focal points? Since most human rights violations are the work of the state or its branches, would these focal points chosen by the states be in a position to push these states to implement the court's decisions, which in principle may be prejudicial to them? That's the first part. The second part says, why didn't the court, maybe Dr. Eno will come back on that, why didn't the court collaborate with civil society instead of the focal points chosen by the states? In my opinion, there is a fear of objectivity. Would you like to respond to the views that, the focal points are basically state agents. The same violators are supposed to be receiving decisions and pushing themselves to implement, the court's decisions. Would that work? Or why not rather, work with civil society organizations for probably a better outcome of that process?
Thank you, Chair.
Okay.
Okay.
Yes,
thank
Dr.
you.
Eno, go ahead.
Yes, let me just indicate that by requesting for focal points, we do not exclude the role of civil society. As I indicated earlier, responsibility for the protection and promotion of human rights is a primary responsibility of the state. And in any case, it is states that before the court, and as such, we have to deal with them in one way or the other. Yeah, so the fact that we get focal point is one way to facilitate our engagement with states, so that if we want to make any follow-up on implementation, we have a mechanism to do so. But that does not mean that we do not engage with civil society. We do work with the Coalition for an Effective African Court, but colleagues should also understand that being a court, the way we deal with civil society, we are very careful, because some of these civil society organizations may end up being litigants before the court. And if we've already exposed ourselves, if we've been seen working with them in a particular way, this may raise preliminary objections from states to say there is a question of bias. So while we work with civil society, there are certain things that we cannot do with civil society. But in terms of collaboration, we work with them, we transmit our draft judgments to them. Right now, we are looking at developing a distribution list, a mailing list, where we are going to be targeting bar associations, the academia, civil society organizations, to make sure that whenever we deliver any judgment, the following day it is disseminated as widely as possible to all relevant stakeholders. Because these are already public documents. And of course, member states are also a part of the stakeholders, so we send to them as well. Yeah, so this is to give wide publicity to the judgments, but now the court cannot go and start telling a particular NGO how it should go about ensuring implementation of that judgment. It behoves now on that NGO to see how it can do it. Yeah, thank you, sir.
Thank you, Dr. Eno. Japhet, you wanted to react to something?
No, it was just on the same point, and I think Eno has really clearly elaborated on it. It is always a paradox of international human rights system that the state is the violator of human rights, but also it bears the ultimate responsibility for redressing those human rights. So the appropriate focal point would be the state focal point. Even if we have, even if it were possible to appoint or designate a certain civil society organization as a focal point, that civil society would need to have a focal point within the state, would need to work with someone in the state. So it cannot, the responsibility of the state from implementing the decision cannot be shifted. And for that reason, the focal point can only be within the state, irrespective of the fact that it is the violator of the human rights.
In fact, that's the beauty of human rights law, isn't it? That the violator must be held to account, and no one should twist their hands they should be arm twisted in doing so, but the rule of law requires that whenever there is infringement of constitutional rights, the state authorities should redress that and be seen to be doing that. With that, I think we have really come to the conclusion of the general, discussion segment, where we're looking at questions that participants were putting across, and I don't see any unanswered questions here. I think we have exhausted them all, and I think that today we are really finishing this session right on time, not more than 3 hours. We have struggled with time before, but today, I think more importantly, because our discussion was quite focused on one particular issue, complex as it is, the issue of compliance with the decisions of the court and recommendations of the African Commission or the African Committee of Experts, but we're able to tease out the issues, the main issues. But probably more importantly, we're able to identify the national actors, you and me, the litigators, and our clients at the national level, the media, judiciary, the CSOs, bar associates, legal practitioners, all those having a role to play in ensuring that there's implementation of decisions of our human rights bodies. So there's no competition, really. That's what I heard from the presentation. There's no competition. The work is clearly cut out for each player. Each player has a specific role to play, but that role synergizes nicely with the rest of the stakeholders, whether at national level or at the international level. The issue of focal points at national level is actually one of the key points of the framework which the court is developing. You need to have someone who acknowledges the receipt of the decision of the court. Not only that, someone who is empowered at the national level to ensure that the different arms of government or of the state are able to coordinate their efforts in fully implementing the decisions of our African human rights bodies. I always say the state is a monster, not monster in a bad way, but just to show you it's a big institution. The state is a big institution. Government is a big institution. There's so many players there, so many decision makers, and so forth and so on. So if you just throw a decision of the court or a recommendation of the commission into the hands of this monster called the state, no one will take responsibility to say, I'm the one who is responsible for implementing this decision. Everybody will wait and expect someone else to act on it. And at the end of the day, no one is going to do anything about it. So having a focal point at least is a beginning of the decision from the court or from the commission. It is put in the hands of a specific institution called the focal point. And then the focal point then coordinates at national level how each actor within the state or government is able to contribute fully to the implementation of that decision. So with those, in many words, allow me to bring the final module 4 to conclusion, and in a way also wrapping up the online training for legal practitioners and CSOs on engagement with the African Court and the African Commission on Human and People's Rights. I was the moderator throughout these modules, and I really thoroughly enjoyed my time moderating, not only moderating, but listening attentively to the presenters and learning each time I was listening to them. So I would like to assume, I have no doubt at all that the objectives of the online training, which I stated at the beginning, building the capacity of lawyers, building the capacity of national actors in terms of engaging with the African Court and Commission, and secondly, to build the capacity or their knowledge in terms of implementation, the role they can play in implementation. I think you agree with me that that has been the focus of our modules, and these objectives definitely have been met. But of course, I don't want to preempt that. I'm sure the Secretariat will follow up with an evaluation process where we are able to say, at the beginning of this training, where were we in terms of capacity? And at the end of it, evaluating ourselves, where are we now? That's important for us to know if this training has been of any use to any of us or to all of us. So the Secretariat will follow up with that evaluation. Please cooperate with that process so that we can inform our new programs that will follow. I'm glad that the audio, the video, the recordings are available for future use or for your own reference to share with your friends, your colleagues who are not able to join us. They are available on YouTube. Secretariat of the ACC will share with you the links where you can download those audios on YouTube or any other platform of choice. But allow me at this juncture to thank in the first place the African Court Coalition for coming up with this exciting program of this online training that we conclude today. Of course, the partnership with the Raw Olympic Institute that is providing the financial and the technical support to ensure that these 4 modules were a success. And of course, our facilitators, we have been here since day 1. There are many, but I have a special mention of all of them. In Module 1, we had Dr. Horace Ajolowoon, who is a staff member of the African Court on Human and People's Rights, to take us through the rules of procedure. And then we had Madame Abiola Idou Ojo, who is with the African Commission on Human and People's Rights. These are the 2 who took us through the first module. The second module looked at in strategic engagement with these 2 bodies. We had, in the first instance, Miss Evelyn Chijarira, of course, the program manager, the Pan-African Lawyers Union, as well as our colleague from the Indo-American system, Miss Florencia Reggiado, who took us experiences in the Indo-American system. And in the third module, we had Eric Bismana, Mr. Eric Bismana, who was looking at inclusion of gender issues in the African Court, as well as Miss Judy Gitau, who was looking at engagement with the African Commission as far as gender issues are concerned. And finally, today we had Dr. Japheth Bigon, who took us through the issue of implementation before the African Court and the African Commission. Of course, we had other presenters who are contributors really of note, like Dr. Eno, who was able to be with us and sharing his experiences, the court, what the court is doing, to give us the practical aspects of what is happening with the court. But more importantly, or above all, to thank our participants across the continent, across the world, who participated throughout with so much interest and enthusiasm throughout the process. We thank you. Otherwise, the African Court Coalition and the Institute could not do anything without your contribution or being available to take up this training. So we really thank you for that, for being available and showing interest in our system. And definitely look forward to seeing you again soon. I have no doubt that the coalition is preparing new programs to come, and you'll be advised in due course. And you also welcoming the new members that have joined the coalition. We receive you with both hands. We look forward to be with you and to be part of the big family, or the larger family of the African Court Coalition. With these words, I do not think that I have anything further to say, but to say for now, bye-bye, goodbye, all the best, and we look forward to seeing you soon. Bye-bye.